Hello and welcome to the Rogers Brief for February 3rd, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. Today's February 3rd. It's the birthday of two former roommates of mine, Adam Houston and John Cedric. So if anybody from the Toronto Zoo or Montreal Canadiens happens to be watching this, make sure you go and talk to them and wish them the best. I'll be in touch with them directly, of course, myself. But anyway, so cold night coming in Nova Scotia too, so I'm going to release this on Friday evening, and if people are at home and trying to stay warm and looking for something to watch, maybe they'll catch up on the week in Canadian legal news and some international flavor as well. I've got a few stories out of Nova Scotia to start with, and then some international. Well, I have a story out of Scotland I think what people will find interesting. And then BC they have a drug legalization pilot that is starting out there. Talk about that a little bit. And then two decisions out of the Supreme Court of Canada that were released last Friday, the 27th of January. But so I had a chance to review those on mandatory minimum sentencing and cruel and unusual punishment, suggestion under Section 12 of the Charter. So I'll talk about those, but first thing, people that have watched watched my videos would know me maybe early on from the Mass Casualty Commission work that I was doing, the analysis and updates that I was giving. Well, the commissioners released an update this week and published that a couple of days ago, and wasn't much in it other than to confirm that they are going to release the final report on March 31st, as they had announced. Well, they had an extension. It was originally going to be in November 1st, but got an extension, a 5-month extension to March 31st. So they've confirmed that that date is still a valid date, and they're ready to do that. They're going to reach out to the stakeholders and others in advance of that to, I think, plan the release a little bit. They, in the release, also talked about their sadness at other ongoing and mass casualties that are taking place, and in their view, how those ongoing events and tragedies underscores the importance of the work of the Mass Casualty Commission. So we'll see. The final thing that they said is that they say that everybody, the stakeholders, the public, government, all have a responsibility to act on the coming recommendations. Well, I mentioned this before. We'll see. I mean, the Mass Casualty Commission has some work to do to reestablish or to establish their credibility, and that so it's asking a lot, or maybe asking too much in advance of the recommendations, in advance of the report, to ask us all to work on implementing them and be responsible for that. I mean, we'll see. We'll see if we find them persuasive and compelling. Then yes, of course, people will be eager to help implement the recommendations, and hopefully some positive change comes out of a terrible tragedy. But we'll wait and see until March 31st. So anyway, good news in a sense that at least they're still on track, or they are finally on track to release the report. Just another thought on mass casualty. The public is not invited to this, but this Thursday I'm going to be speaking with the fourth-year forensic psychiatry class at St. FX University in Antigonish. Dr. Margot Watt, Professor Margot Watt, has invited me in to speak to the class. I was talking to one of the students already, and it sounds like they're pretty excited for it. I am too. They've been assigned to read the Deficits of Trust ebook report that I've published, and so I'm sure there'll be some hard-hitting questions about that. But the other reason is I'm just kind of curious to see what these forensic psychiatry students conclude about this. We didn't get from the Mass Casualty Commission itself a forensic psychiatry analysis or report of Wortman. All we got was two forensic psychiatrists that were brought in, one from Arizona, one from Australia. I questioned why wasn't the Nova Scotia expertise used, but in any event, these experts were brought in not to provide their own sort of original analysis of Wortman, but just to react to a report that the RCMP had provided of Wortman, sort of psychological profile, and they were very critical of that. But we never got to see the psychological profile from the RCMP, and there's no original standalone analysis done by anybody else either. So I'll be interested to hear what these St. FX students think of Wortman himself, and from a psychological point of view, forensic psychiatry, psychological stuff. So anyway, whatever of interest comes out of this session on Thursday the 9th, next Thursday, I'll discuss that probably next week in my Rogers Brief report. So that was the first thing. Next thing that's going on in Nova Scotia, I've been following the William Sanderson trial, the reports out of that. This is a jury trial. William Sanderson was a medical student. He was about to start medical school at Dal. In August of that year of 2017, he was arrested for the murder of Taylor Sampson, who was also a student at Dal, a physics student. This week, so things haven't been going great for the defense. So Sanderson was convicted, successfully appealed, and this is now a retrial. This week, the Crown closed their case yesterday, and so we'll hear on Monday whether the defense is going to call any evidence. This week, there was testimony from Justin Blades. Justin Blades was in the apartment next door and heard a gunshot. He and Pukil McKay, who was the tenant of the apartment, his friend, heard the gunshot, went to their own door, heard Sanderson up and down the hallway a little bit, and then went out in the hallway themselves after a little bit. Sanderson's door was open. They looked in and they could see somebody with a gunshot to the head, blood all over the place, all over the floor, and the guy was slumped over in the chair. Appeared to them to be dead. And Sanderson apparently asked this Justin Blades to help him get a car for him and help him out, and Blades refused. But he didn't say anything to the police at the time, and it was only 2 years later that he spoke to the police. And the reason he gave for that hesitation or that delay was that he was worried that Sanderson had connections to the Hells Angels, and that he was feared for his own safety if he came forward to the police. Which, according to at least to Blair Road's CBC reports, Blades was quite. He was shaking on the stand. He was, very upset. It sounded like a credible witness. The explanation of why wait 2 years was a credible explanation. See what the jury thinks of this, but it seems like things are not going very well for Sanderson. Now, an interesting thing: the day after that testimony, Justice Chipman read an agreed statement from the Crown of Defense that stated that Sanderson did not in fact have any connections to the Hells Angels. Well, of course, Justin Blades didn't know that. He just thought that. But I could see why the defense would want to have that cleared up. I mean, it's just hearsay anyway, but you just don't want that in the minds of the jury, that the possibilities out there. So you want to close that off, and then that agreed statement would certainly do that. If there's no evidence that he had any connections to the Hells Angels, you wouldn't want even that suggestion in the air for the jury. All right, so we'll see. Defense on Monday has to make a decision, or has to announce their decision about whether they're going to call any evidence. The defense is not compelled to call any evidence. You don't need to. You could just rely on the weakness of the Crown's case, if that's your view of things. I mean, the burden of proof is always on the Crown. It's up to the Crown to provide evidence beyond a reasonable doubt that the person's committed the crime. There may be a strategic reason for the defense in this case to call evidence. I'm not sure exactly who they'd call. They have, so far the Crown has connected, made a lot of connections to to Sanderson. There's DNA evidence. Now there's these sort of eyewitnesses. There's cell phone evidence that was brought out this week that showed that Sanderson's phone was in that area. Now what they haven't found is Sampson's body. So without a dead body, that's something for the defense, but I'm not sure if it's enough. We'll see on Monday if they call any evidence. I think they probably should. If they don't, it's probably not a great sign for them. They may have been hoping that something would jump up as it did in the first trial that would allow them to, allow them a defense, but it doesn't seem to be happening. So we'll see. Last Nova Scotia case issue I want to talk about. This was in the news this week. There was a Tuma Young, who's a Mi'kmaq lawyer out of Cape Breton, K.C., King's Counsel lawyer, is also a small claims court adjudicator, and this week wrote a small claims court decision in Mi'kmaq. Now, this was in the news. Now, the decision itself has not been published. It's not been translated into English, so I don't even know what the case was about because that wasn't part of the news story for some reason. It was mentioned in the news story that neither party is Indigenous, so neither party speaks Mi'kmaq, sounds like. So it's not clear to me exactly how useful the decision would be to them. What Tuma Young says is that, this was an effort on his part to show how the Mi'kmaq language might be able to resolve disputes that aren't necessarily based on a First Nation or based in Mi'kmaq culture, but can be used for any dispute, which I agree with. I think that's a nice development. Be interested to see when the decision is actually published and whether it gets translated to see exactly how that might manifest itself. I mean, how is the language or how are these principles being used? Now, I did notice that the Justice Department, Nova Scotia Justice, was asked to comment on it, and they celebrated the development and the use of the Mi'kmaq language in this decision in this way. So did the courts of Nova Scotia through their Twitter account. They amplified the story that was dealing with the case. So certainly the government seems to be supporting this. It's also, Mr. Young mentioned the Mi'kmaq Language Act, which was passed into law last year by the PC government in Nova Scotia, Bill 148. Now this Mi'kmaq Language Act recognizes Mi'kmaq as the first language of Nova Scotia. Now that is not the same as an official language. There's nothing in the act that provides for people to have the right to receive government services in Mi'kmaq or anything of that sort of more formal nature. What it does do is it aims to promote, it talks about promoting the language, and there's a committee formed, and the makeup of the committee is in the act that talks about finding different ways to promote the usage of it. I'd say this using it in court decisions with translation and with the there's some things to talk about there to make sure that it's still using the law in legitimate ways. I think this is a good development. I'll be interested to see if once it's flushed out a little more and see how that might be used more broadly in courts in Nova Scotia, small claims court, criminal court, Supreme Court, all the way through, family court for sure. Okay, so that's Nova Scotia. Those are sort of the highlights of Nova Scotia law news this week. I'm going to go across the water for a minute to Scotland. Scotland has been in the international news because they have they've introduced a gender recognition certificate. Okay, so gender recognition certificate would be that if you wanted to declare that you wanted to change your gender or adopt a new gender, then you can do so. You just fill out the form. Controversial for two reasons in Scotland. One is a jurisdictional one. So in the UK, Scotland isn't the same. It's not a province in the same way Ontario or Nova Scotia is a province in Canada, but they do have a devolved parliament. So the UK parliament is in Westminster in London. There's also a Scottish parliament in Holyrood they call it, in Edinburgh, which has certain authority devolved from it from the Westminster parliament. And so there's a question as to whether this law, which is talking about gender identity, is the jurisdiction of the Scottish Parliament or of the UK Parliament. The argument that the UK Parliament is making, the Prime Minister is making, is that it's the Westminster UK Parliament deals with equalities law, so human rights laws, and this is smack in that territory. So it seems like there's going to be a jurisdictional problem with it. The second problem, maybe the more direct one, is they've had now a couple of instances of biological males who have been convicted of rape, who have been put in female prisons because they're now identifying as female or transgender. So they're being put in women's prisons, domestic violence treatment centers, and homeless shelters for women. So so there's, of course that can't be, particularly in the case of the rapist going to the women's prison. And so there's, some uproar over that. Of course, all of those issues would have a disproportionate effect on marginalized women and disadvantaged women. So that's an issue. So one of the things that connects back to Canada, because one of the examples the Scottish government, Nicola Sturgeon, gave was the Canadian one. Yeah, it's already here. We did this 2017. I think the government of Canada made that. So you don't need to do anything. You don't need to. So in the UK, the rest of the UK, you'd need to either have a medical diagnosis of gender dysphoria or there's a waiting period. In Canada, in Scotland, under the new law, there wouldn't be any such requirement. In Canada, it's the same thing. You just fill out a form on your passport, and there you are. You've got your new gender, or you can male, female, or other gender, which is an X. So we'll see. We'll see how that evolves or devolves over in Scotland. Next story is out of British Columbia. The big story in Canada over the last couple of weeks is last week. British Columbia is exploring further drug legalization, and so they've been granted permission for a 3-year pilot project, which gives them an exemption from the Controlled Drugs and Substances Act, allowing people in British Columbia to possess up to 2.5 grams of hard drugs such as cocaine, meth, MDMA, which is ecstasy, opioids such as heroin, fentanyl, and morphine. So some serious drugs there, obviously. The goal seems to be to combat, the drug deaths. And there's been apparently 10,000 drug deaths in British Columbia just since 2016 from poison drug supply and overdoses. So it's a serious health issue and life and death struggle out there. The exemption doesn't allow people to traffic in these drugs. It just allows you to possess. And there was some argument. BC had asked that the number be 4.5 grams. The federal government only agreed to 2.5. So not sure that's a great distinction, but it was a distinction. It was a negotiating point. So trafficking is still illegal. You're not allowed to possess these drugs at a school, at a childcare facility, or airports. That's still illegal. And then you have municipal bylaws in Vancouver, certainly in other places, where you're not allowed to use drugs in public facilities or in, you can't go to the mall or a store and use drugs there either, in those kind of privately owned but essentially public spaces. So there's some limits to it, but it's still out there. The question I have is, here's the problem that they're trying to address is these drugs are, people are using the drugs. That's, they don't seem like they're going to stop. So the problem seemed to be that the drugs were poisoned and the fentanyl in them or something else, and they were tainted. But they're not addressing, so they want to treat it as a public health issue and treat, people for addiction and do all that. Well, that's fine. But they're not treating the actual problem, which is the poison, because they're not providing a safe supply, presumably because that would be politically unpalatable to many people for the government to actually be supplying drug users with drugs. But if dealers are still getting prosecuted and the supply side is still in the shadows, are they really addressing the problem? It's still dangerous, isn't it? And so I'm not sure that this pilot project is going to have exactly the right effects that the people are hoping for out there. We'll see. My old classmate Dave Eby is the premier out there and has a good head on his shoulders, so I'm sure he's keeping a close eye on these. And people across the country and probably internationally are going to be watching this as well to see. I mean, this is an experiment. I mean, Portugal is really the only other place that developed country that's taken this route. So if it works in BC, maybe, but I don't think they've really, if they're really going to do this and get past the sort of moral issue of allowing people to do drugs and treat it as a public health issue, then, you know, without controlling the supply and the real problem, I'm not sure that it's going to have the success that they're hoping. All right, so that's BC drug legalization. Well, obviously everybody will be keeping an eye on that over the coming months as that pilot project is unfolding. Last thing I want to talk about, these two Supreme Court of Canada decisions, and these were to do with mandatory minimum sentences on gun crimes. This has been in the news a fair amount, and the two cases were Hills and Hillbach. Okay, so in Hills, the gun law was found to be the mandatory minimum of 4 years in jail was found to be unconstitutional. In Hillbach, there was 4 and 5 year mandatory minimums with robbery with a firearm, and those were found to be constitutional. So we'll talk about those a little bit. The section of the charter is section 12, which is a section of the charter which protects citizens from being subjected to cruel and unusual punishment. Actually, it was funny, these cases, they come out of Alberta, and the Alberta Court of Appeal in the Hills case, I believe, one of the two, talked more about the second part of that and say, well, you know, a prison sentence, cruel and unusual. All right, so the cruel part we maybe understand, but the Alberta Court of Appeal judge, one of the judges talked about, well, has to be unusual, doesn't it? And prison is a usual punishment. So how can this even qualify? Anyway, Supreme Court of Canada didn't follow that line of thinking. If a regular sentence would be 6 months in jail and you're given 10 years, well, that's counts as cruel and unusual, even though it's still prison. So the issue that came up in this is reasonably foreseeable hypotheticals. Why would that come up? Okay, so in Hills, the situation was that the person shot at a home with a firearm. And so he challenged the law to say, all right, well, he was convicted, and the mandatory minimum was 4 years. The sentence that the trial judge would have given was going to be 3.5 years. Not a great difference, perhaps. But so the test is, what would a fit sentence be, and then is the mandatory minimum grossly disproportionate to what a good sentence would be? In Hills, okay, so the accused in Hills was convicted of shooting at a home. What he argued, his lawyer argued, was, well, this law covers, you know, the danger of shooting into a home, but a person could have an air rifle, a pellet gun, or some paintball guns. Some paintball guns and some air rifles are included as firearms according to the firearms definitions federally. And so there was some expert evidence on that point. And so the judge said, well, hypothetically, somebody, a young person, whoever, could be shooting an air rifle at a home, and, you know, no risk whatsoever of those BBs or pellets going through the walls into the home, which is the harm that is trying to be addressed by the law in the first place. You can't shoot at a car. You're not allowed to shoot, you know, purposefully or recklessly at a home, because the bullet could go through the wall and hit somebody, and you don't know who's in there. All right, so the controversy in this sense was, all right, this guy didn't do that. He actually shot a real gun and shot it at a home and was convicted of it. And but when you're looking at whether the law itself is valid, the court says you can use hypotheticals that match the law. And they went through a long discussion of what is a reasonable hypothetical, but, you know, they came down and said, yes, there are such things. And in that case, they said, well, if somebody shot at a home with a BB gun or a paint gun, it would be cruel and unusual to sentence them to 4 years in jail. And so they overturned the law, struck down the mandatory minimum sentence regime, and so now and sentenced the person to the 3.5 years, revised the sentence. It was, the Alberta Court of Appeal said that the Supreme Court should revise their whole Section 12 jurisprudence and not use hypotheticals. I don't agree with that, and neither did the Supreme Court of Canada. But in this case, I really looked at Justice Cote's dissenting opinion. There was an 8-1 decision. Hillbach was 7-2. The Hills was 8-1. Justice Cote suggested that the real way, the proper way to decide that case, the hypothetical of somebody with an air rifle is, well, they don't have then the mental element of, in any crime you need a physical element, you need to do the crime physically, not be compelled to do it or physically forced. And then you need to have the mental element of you meant to do it or you were reckless as to the consequences. Well, Justice Cote said somebody with an air rifle shooting at a home doesn't have the mental element because they would know that their rifle isn't going to be able to penetrate the walls and go through. So I thought that was probably the better way to do it. I mean, I don't think it would offend people's sensibilities if people were, shooting real rifles and handguns at a home being sentenced to 4 years in prison. That's a serious thing to do. The Hillbach case was similar in a sense, but it went the other way. The distinction seems to be whether you know where you're firing. This Hillbach case was a 19-year-old Indigenous youth who was robbing a store and also challenged the law to say, well, hypothetical offender with an air pistol still is going to get the same mandatory minimum sentence of either 4 years with a firearm or 5 years with a prohibited firearm. Hillbach had a prohibited firearm. So what the court says is nope, because there is, even in that case, you're not pointing at a wall, you're pointing your gun at a person at a store, you're robbing a store. There is still in that case a risk of life-altering injury. You could shoot somebody in the face, you could shoot them in the eye, I guess, or you could do some damage with a BB gun or a pellet gun, air pistol. And also, there's a risk of significant psychological trauma for the worker, whoever's being robbed, that they would have, to live with that, and that's just as damaging, or that is significantly damaging enough to justify, in the Supreme Court's mind, the mandatory minimum regime staying in place for that offense. So, in both cases, they used what they considered to be reasonable hypotheticals. And reasonable hypotheticals, I mean, there was a 5-part test for what is a reasonable hypothetical. Basically, you can't be far-fetched. It helps if there's actually if you look at a previous case where things actually happened, but you can bring up anything as long as it fits and it's not far-fetched and doesn't have all of these mitigating factors that are weighed against the law in a sense. So interesting that the Supreme Court struck down the mandatory minimum in one case, upheld it in the robbery case, and so we'll see. That will be up to Parliament now to turn that down. Now, whenever you're looking at mandatory minimum decisions, it's good to keep in mind that judges, courts, there's a tension between the courts and the Parliament. Parliament wants to say, all right, this is, we're in charge, we set the law, and the judges want to, as an institutional thought, say, no, it's up to us, judges, to sentence and use our discretion, sentence the individual in front of us, and not be hamstrung by mandatory minimums or too much guidance from the Parliament. But so there's a sort of an institutional desire to strike down mandatory minimums, which may have come into play in this Hills case. I tend to support the Cote dissent in this one. Anyway, we'll see what Parliament does with it. I suspect this Parliament will leave it in place. Maybe a future one will make a change. So Those were the cases and the situations I wanted to discuss this week, and hope people found that interesting. If you did, if you enjoyed that, please be kind, like, subscribe, share it, distribute it out there, and we'll build the audience and keep things going. All right, so until then, thanks again to everyone for watching. Thank you for listening, and we'll see you next week.